So we'll call the first case, Lorraine McDaniel versus Charles McDaniel. Mr. Smith, are you ready, sir?
Yes.
How much time do you want to reserve, if any?
5 minutes, Your Honor, if I may.
Thank you. You may begin,
Please, the court. I'm Horace Smith with the firm of Smith, Hood, and Perkins, Daytona Beach. Represent the former wife and appellant, Lorraine McDaniel. This was a case involving a 6-year, 3-month marriage, which took place originally in California. The parties were married in December of 1997. The petition was filed in March of 2004. While we've cited approximately 5 issues, I'm going to, for the purpose of my argument, pertain basically to the first 2 issues and count the issue 1 and issue 2. In those particular cases, what occurred in this particular case was that the husband, prior to the marriage to the wife, was employed at a corporation known as Baxter. Just prior to, about 19 months prior to the marriage, he then was offered a position with a firm known as Medtronics. When he was offered that position, he bargained with Medtronics as for a separate contract, and that contract has been placed into the record numerous times. But in that particular contract, he indicated through his bargaining powers that he was losing certain rights by moving, and he was losing some retirement benefits that he would otherwise obtain if he stayed with Baxter. At that time, he was age 52. His planned retirement was age 58, and he indicated that while he maintained his Baxter retirement, that his retirement would benefit even more if he stayed at Baxter. And so as a result, he requested additional stock options, 1 for moving, and 2 to increase those stock options to increase his retirement once he comes to Medtronics. A letter of an offer was made and accepted by the husband, and he moved. He then began working for Medtronics, and thereafter obtained stock options, and they vested on a yearly basis throughout his employment. His retirement also benefited, and he later was, because of Medtronic's layoffs, he worked approximately 4.5 years, or approximately 5 years for Medtronics before moving on to another company. While married and while working for Medtronics, after receiving the stock options and the options which were based upon his reduction in retirement, all of the funds were later the Medtronic stocks of the options, and also those stocks he received for reduction in his retirement. All of those stocks were placed in an account that was known as a UBS account, and that's the account we referred to throughout the brief. Those accounts, which totaled over $1 million worth of stock, consisted of both marital stock and non-marital stock. Some of the stock options that he obtained prior to the marriage, some of the stock options he obtained by the change in employment. The other options were admittedly marital stock, which he obtained not only through stock options while employed, but also stock options that were paid to him for the decrease in retirement. Each of these stocks, both the marital stocks and the non-marital stocks, were placed in the same account. So they were commingled in that particular account, but being stocks at that point, there can be somewhat, but you can trace them. However, afterwards, the husband sold those particular stocks. Those stocks then went into what's called an AIM account, AIM account, in which the cash money went into the account, over $1 million. Later, that AIM account was used to purchase a mutual fund in 3 different areas. We refer to those collectively as the American funds. Not only did the stock options, which were both marital and non-marital, go into those particular funds, but also an additional $30,000, which the parties had from sales of from their previous homes, also went into that account, and that was also, without a doubt, marital. Later, when the trial court heard this particular case, the court adopted a theory of the former husband in this particular case, which is a theory which has not been used in Florida law, to my knowledge, and that was called a percentage theory. The CPA by the husband testified that it was not her findings as a CPA, but only upon directions by the husband and his attorney did they use a percentage theory. In fact, she says she did not understand the law between marital and non-marital and how those were to be handled, so the husband's attorney gave her the prerequisites that she was to look for to come up with a percentage theory, and basically to take...
Well, do you agree percentage theories have been used in cases involving real property? For instance, when someone's put a down payment on their house, would you agree with that?
It was used sometime prior, before the land rate decision. It was used in that particular case. After the land day, the percentage theory has not been used very much, except when you can designate how much money would go into the particular account, and you show that there was a special equity. It's only used in a special equity type situation, and has to be pled. If the special equity is not pled, it cannot be used under land day in the real property sector. Of course, here we're dealing in the personal property sector. I'm not familiar with any case that's ever been used. They've used the coverture theory in certain cases for retirement accounts. But that's usually when the retirement account is still existing of a particular stock, and we use the coverture theory.
If the trial judge had determined these assets were marital, more in line with your expert's testimony, would the trial judge still be required to distribute it 50-50, or could the trial judge find that equitably more should go to the husband because of the fact that this is a late-in-life marriage, second marriage at least for both, and a short-term marriage?
Well, assuming that the trial court wanted to make an equitable type finding, which would be contrary to existing law, but if he wanted to...
No, there's a case from the Fifth, and it's now monarchical, where it's a short-term marriage. Both parties were in their 50s. Both parties had previously been married. The husband came in with far more premarital assets than the wife, but put those assets in joint names, and the court found that 50-50 would not be required or would not even be appropriate in that situation.
Correct, but in that particular case, the court outlined in detail why he felt that the equitable division should be done. The court did not find that in this particular case. The court found simply that the funds were non-marital, not recognizing that there was a commingling of the marital funds and the non-marital funds. So that was the problem. If the court wanted to go outside that and try to justify an equitable theory, she certainly has that right. He did not do that in this particular case. He did not find that there was an equitable reason. That was argued in the husband's brief, but this was not a finding by the court. And instead, the court found that and used the percentage theory, of which I'm not aware of any basis upon a percentage theory. But using percentage theory, he then awarded and found that the funds basically were not commingled, sufficient to work in an equitable distribution where you start in half and half type situation.
Counsel, did you find any case in Florida or outside of Florida that deals with a percentage approach and says when you use it, when you don't, or how you use it, or how you don't?
No, sir. No theory. There are cases in Florida which, like I say, in retirement, using the coverture theory, the number of years marriage over a number of years worked, and divide that, and that's used in retirement funds, and we do that quite often. But we don't do that in non-retirement type funds. And in this particular case, as the husband's expert testified, she testified very frankly, is that the funds were both marital funds and non-marital funds. They were commingled. She couldn't tell one stock from the other that was used. It went into cash money. It was fungible. She could not identify $1 from the other dollar, and then additional dollars came in from outside, which were obviously marital funds. And then the funds were divided. And so on the commingling theory, certainly it was a commingling. The second point dealt with, in the first point, we assumed we're going to say, okay, every stock which the husband says is non-marital is non-marital, but nevertheless there was a commingling. And the second point is that we disagree with the stocks which husband says these are non-marital stocks, because number one, there were stock options, and the main issue, it goes back to the letter of Phil McLaughlin and his deposition. That's the point, and it's paragraph 9 in his particular letter. Like I say, it's pointed out in several places. The stock options, not only the stock options, but additional options were given to the husband for two reasons. One reason to encourage him from coming and what he's leaving behind at his previous corporation. But the second reason was to also to place with him retirement funds, to replace the retirement funds, not ones that he's leaving because he left nothing. He received his retirement from Baxter. What he did was calculate on his own in his bargaining position. As you look in the Laughlin deposition at the end, attached to his deposition, the first page, is the husband's bargaining power, what he says he's leaving behind. And he says he was leaving behind approximately $1.7 million, which would increase from the time he starts with Medtronic to the time that he is terminated from Medtronic. It's somewhere from $59,000 a year. He wanted that retirement replaced, and they agreed to do that. Now, if he'd have stayed at Baxter and he's married, the wife would have shared in that retirement without a doubt. He had to be with Medtronic for those 4 or 5 years during the marriage in order to get those retirement funds also. So the wife should not be cut out of his retirement benefits simply because he changes corporations. If that were the case, we certainly would then have a loophole in the law. If a husband maintains retirements and then he can cut the wife out of future retirement by changing jobs, we would have a loophole that could be taken advantage of. And yet, as the husband's own calculations would indicate that his retirement funds eventually are going to be worth $1.7 million at a rate of $60,000 a year. The wife lost those particular funds. So going back to that particular scenario, if we look at which funds were marital and which funds were non-marital.
I'm sorry, how much did you say she lost a year?
I'm sorry.
How much did you say she would have lost a year? Or he would have lost a year in retirement benefits?
He calculates he would have lost $59,000 a year. He then used that over a period of what he used as a 80-some-odd-year-old person, his life expectancy, and calculated at $59,000 a year at $1.7 million. That's what he valued the retirement benefits of moving were, and that's what he bargained for Medtronic to give him. And so he actually worked during that period of time at Medtronic. The wife was married to him at that time, and so she should share in those retirement benefits also. This time I'll reserve the rest of the time.
Thank you, Smith.
May it please the Court, I'm James Rose, the law firm of Rice & Rose, represent the former husband, Charles McDaniel. I believe the recitation of the facts given by Mr. Smith are accurate. To highlight a few other things, when the husband entered into the marriage, his net worth was approximately $1.7 million, in addition to the Medtronic stock options that he had bargained for. As Mr. Smith said, Mr. McDaniel entered into a contract agreement with Medtronic prior to the marriage, some 19 months prior to. And getting to the chase here, he did sell the Medtronic stock at the time and after his marriage. And what we're concerned about here, Your Honors, is that when Mr. Smith says we did a percentage, probably that is true. Monies are fungible. We're talking about a finite amount of transactions here, and this is a court of equity. So what we have here is Mr. McDaniel selling stock from stock options, the predominant ones being just non-marital, as we had argued in the trial court. These monies go into a short-term account just in his name, and then taken from there and purchase these American funds just in his name. Now, Mr. McDaniel had this account for a long time just in his name. Most of the time, and most of the case law that I have reviewed says that when you have commingling, typically you have an inheritance going into a joint account and money's coming in and out. You really cannot trace them. In this particular case, Lisa Park, the CPA who was hired, she testified that she could trace these monies. This is not a situation where you have a lot of transactions going on. You essentially have the sale of 6 stocks going into one account and going to buy 3 other accounts.
Did the trial judge make a finding that they were traceable as well, or did the trial judge have problems with that?
He made no specific finding, but he accepted the argument that we made as in our trial memorandum, which that was the argument, Your Honor.
Mm-hmm.
So this is not a classic tracing situation. Those funds sit there today. Nothing has happened to them. No other monies have gone in or out.
But you had an expert witness that was able to do that with calculations. You felt the trial judge accepted?
Yes, sir. Specifically in her testimony, Ms. Park testified that she had no trouble tracing the monies and gave an example. If, for example, you have $325,000 of non-marital money and you put $1 marital money in, by definition of the argument of the appellant, that becomes commingled. So far, we can't tell what's what, therefore it's got to be 50-50. And that's not equitable. And again, in this case, we have a finite amount of transactions, and we believe the trial judge, whose decision comes with the presumption of correctness to this court, made the right decision in saying that in fact, Mr. McDaniels identified specifically those stocks that the court determined to be non-marital, and even though there's been a transaction that puts them into a money fund, that in fact they are traceable. And again, that being a court of equity, we believe the court should uphold that aspect of his ruling. As far as the stocks themselves, it's the appellant's complaint that the stocks themselves from Medtronic should all be considered marital in some manner. The testimony was there were 5 different kinds of stocks on the options. 2 of those options, those listed in number 9, which the alternative A, we argued at the time should be considered non-marital. The other stocks in the other parts of the agreement, we apportioned in a coverture. You know, how long were you married versus how long you worked there. So we're only talking 2 stocks that we believe that would be considered non-marital. And the husband's unrebutted testimony basically was the reason he got these stocks is because they were out to recruit him, they being Medtronic from Baxter. Mr. McDaniel had worked for Baxter International for some 23 years as a high-level executive. What he was being asked to do by Medtronic was to give up a lot of security, a lot of stock options, and a lot of things that he had to walk away from, and he wanted some assurance. So he bargained with Medtronic, and he wanted stocks right away. Now, the court, it is true that some of these options in number 9, which is the one we're dealing with here, he got them granted, and there's our argument at the time of the grant they became his, even though they did not technically vest. They vested every 4 years in one part and every 3 years, every third year in the other, or 50-50 in the other. But the court in Ruberg has found, the Ruberg court, that it doesn't matter exactly when you actually exercise them. The issue is what is the nature of the stock and why did they get it. So it is our contention that those particular stocks as described in paragraph 9 were given to the husband as part of his inducement to go to Medtronic, and therefore they should not be considered marital in nature, whereas the other performance stocks and the others that are described in the agreement, we have no problem saying those stocks that were earned during the marriage should be considered marital, those earned before the marriage should be non-marital, and that's what the judge in the trial court below concluded. So we believe that, again, it's a finding of fact under Ruberg and Perry as to what the nature of the stock is, and we believe that the judge made the finding implicit. He did not specifically say, but again, that was what was argued in the trial memorandum submitted to him, and essentially he accepted the argument of the husband. In regard to the alimony issue, we again believe the trial court denied Ms. McDaniel's request for alimony, finding that the alimony scheme was ill-conceived. Again, that finding comes with presumption of correctness to this court. As the court saw in the record, the parties were separated for some 18 months. Ms. McDaniel had the opportunity to go out and try to get rehabilitated. She had sufficient funds, and she had taken some joint funds of about $100,000 out. Never did it. It is also in the record that Ms. McDaniel was, when she was asked to go to work beforehand, before the party separated, never did it. So that testimony, we believe that the trial court rightfully found that the rehabilitative scheme was not something that they should explore. In regard to the house issue, one of the issues in point 4, I believe, is that the house itself...
Getting back to the rehabilitative alimony, did the husband ever agree that, that the wife would receive that?
He made an offhand comment in the record, Your Honor, that if it was rehabilitative...
They seem to argue that there was an agreement.
There's no agreement. I mean, we denied it in our answer, we denied it in our trial memorandum, and we said no in our proposed final judgment. But what they're hanging their hat on is that Mr. McDaniel in an offhand comment said, I suppose if it's rehabilitative and it's monitored, okay, something to that effect. But certainly that's not an admission in the middle of a trial when he's doing his testimony. It has been consistent that the husband says there should be no alimony of any kind, rehabilitative, permanent, or otherwise. And again, that was argued in the trial memorandum. As far as the house issue goes, one of the issues that came up is that the home itself is income. The court found that there was a debt attached to the house. Technically, there is not a debt attached to the house. However, it is a line of credit that has specifically been used for the home. And again, it's kind of a red herring whether it is attached to the house or whether it's not. It's a marital debt, so it has to be dealt with one way or the other. So we believe that the trial court was correct in finding that even the husband, in this case, has right of first refusal to buy the home and should be responsible for the debt. Again, it's marital one way or the other. Finally, in regard to the attorney's fees issue, we believe that the wife has sufficient assets under the terms of this final judgment. She has approximately $700,000 in liquid assets that will be coming to her under it. She has sufficient funds to pay her own attorney's fees and costs. Anything else?
Thank you.
Thank you.
The comment he made was a direct question. Do you think your wife is entitled to alimony? And he gives rehabilitative alimony. He said, yes, if it can be monitored. That's not an off-the-record kind of comment. That was a direct question asked to him.
What was the cost of the rehabilitative plan? It's $4,100 a month for...
I think it was around $2,100 a month. It's for her to go to school for approximately 2 years and then to be supported during that time.
I think, was it for 3 years, though, $4,100 a month? And then there was approximately $10,000 for tuition and books.
Yes.
Now, was part of a rehabilitative plan also that she get the marital home this year?
No, that's not part of the marital home was a separate issue altogether.
But she did ask for the...
She did not ask for the marital home. The judge ordered it be sold, and with the husband having the right of first refusal, the question about that was that there's a separate credit. The judge found it was a mortgage. It wasn't a mortgage, as Mr. Rose pointed out. It was a credit line from a UBS account, which in itself is joint because of the commingling again, the same UBS account we were talking about previously. The court just said that that's his account. We consider that account also a joint, so it's a joint credit against their own funds.
Okay, but the plan would have cost about $150,000 total to get a starting job between $25,000 and $32,000 a year as a property manager, right?
Yes.
Okay, now there was testimony from your expert, wasn't there, that she could make a job at $24,000 a year if her back had allowed her to do it, going back to her prior type of work.
Correct.
But they argue that she was physically able and put on evidence that she rode horses, played golf, skied, played basketball. If the trial judge had evidence that she was able to do the job she did before at $24,000 and make $24,000 a year, according to your expert, then is it reasonable for him to conclude that it wasn't a good idea to have a plan to make $25,000 a year when the plan was going to cost $150,000?
He made no finding at all. He just denied alimony and said there was a presumption against alimony.
But was there substantial competent evidence which would support a finding that she was capable of doing the type of work she had done previously?
She was incapable. That was a...
Well, that's what you're
He made no finding, is that. He just said she can find a job.
Right, but was there competent evidence in the record which would support that finding?
We do not believe so. Let me get back to one of the 2 points I was talking about first. Counsel argues that the expert that they had could trace the funds. I pointed out to court in my brief, and I point out on the record, the transcript on volume 4, page 431, when they were asked, and she was asked, the cash, you cannot trace specific dollars. That's what she says. You cannot trace specific dollars. There are no serial numbers there. And so it was asked, then you're not talking about having specifically traced an asset, are you? The answer is no. Later, she was asked, on page 390 of volume 4, do you purport to make any opinion as to what is marital and premarital? I do not. So your analysis based upon the one that Mr. Rose, the lawyer, gave you as to what was marital and non-marital. Yes. And so she has said she cannot trace these at all. She's only based her theory of what's marital. She didn't, as an expert, didn't even find that this is marital and this is non-marital. She was told by the husband's attorney, this is the way you do it. Now, based upon what the instructions I've given you, now you tell us that this is traceable. She said, I cannot trace the money. I can just do this on the percentage theory. As I said, it's not a theory which is supported by Florida law. The case is clear that there was not only a commingling, but also the court would look at the letter that the Laughlin letter of March 18, 1996. What he was going to be given, this is the agreement he entered into. In order to offset the value of unvested stock options, which would be forfeited. Okay, that's number one. That's one of the things he got stock options for. That's clearly non-marital, and we have no problem with that. And the differences in retirement plan benefits calculated through the age of 58. That, he was working for him through 58, 57, until 56 since he was terminated. So he was bargaining for the retirement benefits, the difference in retirement benefits that he would have received and now he's going to receive. She did not get any credit for any of that. This was his bargaining, and part of the contract consists of non-marital, which we agree, and the other is marital. And the contract is the difference in retirement plan benefits calculated through the age of 58. The court did not find that any of the UBS stock accepted their particular theory that what they said was non-marital, which was all of it under this particular contract. As the contract shows, part of it is marital. When you figured in the marital part, along with, even if you went to the percentage theory, it wouldn't be the 800,000 versus 130,000 that the court finally ended up doing under the percentage theory. It would be much greater. So not only was there a commingling, even under their experts' testimony, but the wife was not given credit for the marital portion of the stock options.
Thank you, counsel.